Obricki versus Melissa.
For the record, this matter is before the court this morning on the plaintiff father's motion to modify the minor child's school. This hearing is being conducted via Zoom. Present is attorney Nicholas Darren representing the plaintiff father, Brian Obricki, and Mr. Obricki is present. In addition, Melissa Obricki Sargent is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning, Your Honor.
Good morning, Your Honor.
The court has been informed that Ms. Sargent, you wish to consult an attorney. Is that correct?
Yes, Your Honor. Respectfully.
Right. What the court's suggestion is that we schedule this matter for mediation. Mediation is going to be 30 to 45 days out. That should give you plenty of time to get an attorney on board, or at least talk to an attorney. The mediation is not binding. Mr. Darren, you have no objection to attempting to mediate this matter, correct?
Never have a problem with ADR, Your Honor.
And certainly it's a kind of issue that these parents should be able to make that decision rather than the court making the decision. We do have time. The child that currently attends school where in Wayne County?
No, in Bedford.
Oh, Bedford. Well, Bedford. Even though dad lives in Plymouth, mom lives in Toledo. But works in Monroe. Okay.
Your Honor, that's incorrect.
Okay.
Mom lives in Bedford, Your Honor.
Oh, okay. All right.
That's the best thing about meeting.
Right. The court has us mediation dates. Ms. Ansbrecht, we can enter an order that the matter parties shall meet at such a date. And what the court will do is schedule a review or status conference immediately following that mediation. So if in fact parties cannot reach a resolution, at least the court can schedule a hearing date. Obviously, time is not of the essence, but we need to make a decision. Obviously, it's prudent that we're dealing with this sooner than later. Some people come before the court 2 weeks before school begins asking for a school change, and it's pretty difficult to squeeze in a hearing at the last moment.
Yeah, and then we filed our motion in March, Your Honor, for that very reason. That way, if the court wanted us to mediate or we needed to have some conversations, we'd have a little bit of time to do that.
Okay. Right, Ms. Anderson, I'm not sure if you have an updated list. The court has a list of mediation dates with Mr. Walker and Ms. LaPrade. Data as of last week, but how about even we've got, I'm looking at the month of June. Maybe in, how about like June 13th? That is a Thursday. And I know for the parents' work schedule, would you prefer 8:30 or 1:30 mediation? And figure it may last a couple of hours. Ms. Sargent, Mr. Obricki, do you prefer 8:30 or 1:30?
I'm actually open that whole day that you just gave, Your Honor, the 13th. So whatever, I know my client works 1 week on, 1 week off. So if he's off that week, that'll, Brian, unmute. Are you good that week?
On that week, I'm working overnights. I would get off at 7 a.m. And then if we absolutely had to, I'd try to grab a little bit of rest before meeting in the afternoon at 1:30.
Your Honor, we only have a morning 8:30 a.m. on that day now.
Yeah, it's just 8:30. So you prefer 1:30 then, Mr. Obricki?
If it were on that specific day.
So, Your Honor, if we went the week before or the week after, he would be off. So then we could do either one, morning or afternoon.
Actually, we have June 13th at 1:30 with Mr. Walker.
Mr. Walker is not available anymore on the 13th, on June 13th.
Okay. All right. I'll cross that date off.
Yeah. The next date I would have for a 1:30 would be Friday the 7th. That'd be June 7th with Stephanie LaPrade.
If I may.
Yes, Ms. Sargent.
So just to place this on the record, I did speak to an attorney already, Your Honor. The issue is securing the funds for retainer, basically. I would ask for that date to be on the later side, due to the fact that I did just secure a second job to secure the funds for that. I start that job in 2 weeks. So if we could do June 7th would be a little bit early from the math that I was doing in regards to retaining, but also the June 13th time frame at 1:30 wouldn't work for me as well.
How about the week of the 17th?
I've got, no, it's not available. How about June 27th? We have June 27th available with Mr. Pratt, either 8:30 or 1:30.
Yes, Your Honor.
It's a Thursday.
I can do 1:30 if that works for the parties. Oh, wait, actually, no, I won't be. It'd have to be the day before. I'm going to be gone the 27th.
Okay, so the 27th will not work. Okay,
Yeah.
how about the,
I could do the
how about the
26th.
how about the 28th, the Friday morning, 8:30?
I'm gone for the weekend, Your Honor. I'm leaving Thursday, and I'll be
All
gone
right.
Thursday, Friday, and Monday.
Okay. How about, we got the 20, okay, the week of June 24th, you'll also be gone, Mr.
No,
Darren?
no, I can do the 25th or the 26th that day.
No, we just have the 24th. I have specific dates and times that the mediators are available. June 24th with Mr. Walker at 8:30 or 1:30. That's a Monday.
I have the 1:30 p.m. available on the 24th.
Okay.
I would
Are
be
you gone that
available that
entire
day.
week?
I mean,
So
I can get somebody to cover it for me. I mean, the mediation, it's not a big deal.
Right.
The 24th.
Okay, let's go into July. How about July 1st?
I'll be back the 2nd. I'm gone the 1st. So
All
I
right.
can do any day though.
I have the
July
3rd.
11th. How about July 11th? We have 8:30 or 1:30 with Mr. Pratt. July 11th. It's a Thursday.
That's fine.
Mr. O'Bricky, Ms. Sargent,
I'm unable to on July 11th.
the entire day?
The entire day, be out of town.
Okay, how about July 12th? At 8:30.
That's fine.
Respectfully, Your Honor, I apologize. We had a week-long family trip, annual trip from July 6th through July 13th.
Your Honor,
Okay.
Your Honor, we can do that June 24th date. Like that's not a big deal. I have 3 other attorneys in my office that are beyond capable of handling the mediation for me.
Was July 3rd an option?
I have a trial in Third Circuit. So
How about July 19th? It's a Friday morning, 8:30.
that's fine with me.
I'm available, Your Honor.
I'm sorry, could you repeat? Is it July 18th or 19th?
July 19th, it's Friday morning, 8:30. July 19th, 8:30 with Mr. Pratt.
I'm available at that time, Your Honor.
Okay. That works with you, Ms. Sargent?
Yes, Your Honor. Thank you.
All right. All right. Just for the record, Ms. Sargent, you're still at 7.
Correct, Your Honor.
All right. Right. The court may allow notice, the parties to appear to be a Zoom mediation with Mr. Pratt on July 19th. That's a Friday morning, 8:30 a.m. And status conference subsequent there too before the court.
Okay.
And Ms. Sargent, Mr. O'Bricky, keep an open mind. Obviously, the two of you know what's best for your son, your child. And hopefully you can reach your own agreement relative to school. Maybe check out the schools and look at if we need to modify parenting time. Remember that needs to be done to make it work. We've got certainly obviously you have a distance between the schools, between Bedford, Monroe, Catholic schools, and St. Francis Cabrini. So check out all the options and see what's the best for your son. And we agree, Ms. Sargent, that your child no longer requires the IEP.
Yes, that's correct, Your Honor. However, he is on the wait list for an actual medical diagnosis for ASD, Your Honor. That has not been, that evaluation has not taken place.
Okay, will that be completed before July 19th, the mediation? Because obviously that's relevant.
I honestly am not sure. I will state that I reached out to Jessica Palladino, attorney Jessica Palladino, who gave me some information about another agency that is attached to the University of Michigan. If you go through there, they can do an initial assessment, and if there's basically that initial assessment can kind of supersede and kind of push him up in the wait list. So I intend to call that agency and see if I can get that kind of moving to push that process, speed that process up. However, when I spoke to U of M a month and a half ago, he was still on the wait list, and it indicated within the next 6 months or so.
Okay, well, perhaps the court suggests make some additional phone calls. Maybe if they hear from someone, they can make sure you're still focused and you want that done, and tell them you got a time frame, and hopefully that could be accomplished between now and July 19th.
Correct. Thank you. I will, Your
All
Honor.
right, all right, so certainly reach out to that attorney and make sure the attorney gets this date on their book. It's far enough away that attorney should be able to make it work, Ms. Sargent. So we'll see everyone. We'll provide you with Ms. LaPrad's Zoom ID number, July 19th at 8:30, and subsequent appearance before the court. Anything further, Mr. Darren?
Nothing further, Your Honor.
All right, if there's nothing further, that will conclude this matter. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor. The new recommendation should be in your queue.
Jeremiah Kuzno, Senior, thank you, also present. Good morning,
Thank
everyone.
you, Your Honor.
Good morning.
The parties have conferred this morning with the front of the court with the following recommendation that mother supervised visit shall continue at Family Counseling Shelter Services. So has that in fact begun?
Yes, it has, Your Honor. She just now started the visits. She's had them the past 2 Wednesdays.
Good, okay, and that's what's scheduled every week?
Yes, they didn't schedule it this week. They apparently sent over a letter to the court, and they stated since she had court this week, they didn't want to schedule one until they heard how this went, I guess. But yes, they will be continuing moving forward.
All right, and the court trusts that Mr. Kuzno will cooperate in that regard. It's further recommended that all medical information regarding the minor children, not only Megan, but all 3 children, be shared by the parties in app close. I think that's included, not limited to medical appointments, dental appointments, counseling appointments. It's further recommended that father shall reach out to Family Counseling Services for an intake appointment for family counseling. And further, that Megan shall be enrolled in individual counseling at Christian Care Connection. And this recommendation does have the phone number for family counseling and shelter services. Following parties will hear back before this court to review these issues on July 10th, 2024 at 8:30 a.m. That's the recommendation. Ms. Spencer, is this recommendation to be with your client this morning?
Yes, it is. Thank you, Your Honor.
Ms. Sills, is this recommendation to be with your client this morning?
Yes, Your Honor, thank you.
Who's going to schedule the counseling session who's going to take initiative with Christian Care Connection?
We actually already did that. My client called while we were meeting with Ms. LaPrade, and the first appointment has been scheduled, and both parties are aware of the date and time. And then moving forward, they will obviously work together to continue those. Okay,
and will Mr. Kuzno bring Megan to the appointment, or will Mrs. Kuzno pick her up? Have they discussed how that's going to happen?
Yes, they're actually being conducted on Zoom due to the parties' work schedules. The latest appointment they could do was 4 p.m. So they will be at 4 p.m. via Zoom.
Very well. Ms. Spencer or Ms. Sills, either of you want to barge your respective clients regarding this recommendation this morning?
I
No,
do,
thank
Your Honor.
Ms. Spencer?
No, thank you.
Right, court will adopt the recommendation. We'll send one back on July 10th at 8:30. Just one last word, Mr. Kuzno. Your daughter Megan would benefit if you encourage and support the relationship between her and her mother. She needs a mother. She has one mother in this world. Obviously, the court sees all the time when children are getting older, there's always conflict. Sometimes it's with mom, sometimes it's with dad. But again, you both got to be on the same page for her best interests. So be supportive. Tell her she's got to respect her mom. She's got to talk to her mom. She's got to, she's soon to be a young adult. So that goes a long way to restoring that relationship. So the court would strongly encourage and recommend that. Best thing you can do for your daughter, Megan.
Yes,
All right,
sir.
the court will adopt the recommendation, and we'll see everyone back on July 10th at 8:30.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, Mr. Brad. For the record, this matter is before the court on the defendant father's objection to referee record order, which denied his motion to modify custody. Court knowing that he failed to appear. This de novo hearing was scheduled this morning at 10:30. It's now 10:45. It appears that neither party has appeared. There is no proof of service of this motion notice of hearing upon the plaintiff mother. However,
Your Honor, the objection is actually to a referee's recommendation for a bench warrant.
Oh, okay. It wasn't real clear from the court file.
Let me,
Because the defendant's pleading talks about the minor child has been living with him since September of 2023 and attending school in Westland, and that mother's dealing with some substance abuse issues. So
Correct.
I get,
so he handled this in multiple ways, which I think is why there was confusion and why he didn't appear today. He had a referee recommendation for a bench warrant. He filed an objection along with a motion to modify custody and a request to abate support, all at the same time, because the only way that the friend of the court stops bench warrants is with an objection or a payment. So the friend of the court has abated support based on his other filings. And I believe that's probably why he didn't appear today, because he already had a hearing that kind of addressed that issue. And I don't think he realized that this one was still going. But he no longer owes the substantial arrearage that resulted in the referee's recommendation for a bench warrant.
very well, the court file does reflect a notice of redirection or abatement of child support. Signed by Ms. Patrick, indicating that the minor child appears to be residing with the payor, Mr. Williams. But he also filed a motion for custody. So I guess the court should enter an order denying his motion for change of custody. He's not appeared. So
That's
he's got
not
to
up for
refile that.
today, Your Honor. The only thing that is scheduled on today's docket is his objection to the referee's recommendation for a bench warrant.
Okay, is there a referee hearing scheduled on his motion to modify custody?
That already took place, Your Honor, on April 17th.
Okay, and well, the 21 days says Court Attorney Rebecca Hicks. Good morning, Mr. Carlson.
How you doing, Your Honor?
Good. We're of course appearing before the court on the outstanding bench warrant that I discovered yesterday, and you were taken over to jail on yesterday for failure to appear, I think, on a review for spousal support arrearages. Any event, just let me finish for the record. The court also conducted a hearing yesterday on an alleged violation of a restraining order. The court found Mr. Carlson to be in contempt of court. Subsequent to his acknowledgement that he violated the restraining order, he was ordered to serve 5 days in Monroe County Jail. Immediately, the remaining balance of 40 days was suspended, reserved, and that was yesterday. So if the court can calculate your out date, probably like Friday night or Saturday morning, Ms. X. I don't know how the sheriff's department calculates. Did the judge give you an out date, Mr. Carlson?
We're showing the 11th, Judge.
Okay, Saturday. Okay, Saturday morning. Ms. X, can you bring the court up to date on this front of the court bench warrant?
Certainly, Your Honor. In this matter, it is an arrears only case. The current balance is $204,787.79. There was a show cause hearing scheduled for September 12th, 2023, where Mr. Carlson failed to appear. We held off, and the bench warrant was issued and went on lien on October 2nd of 2023. Looks like the last payment received was July 19th of 2023 in the amount of $1,000. That was a bond payment the last time that he was incarcerated on this matter. He does have a previous finding of contempt. It's from April 10th of 2023. It is a first finding, and he does have a 20-day balance.
Okay, do you understand all that, Mr. Carlson?
Yes, can I speak, Your Honor?
Yes, please.
So the September 12th, when I was in contempt or whatever, I was in jail in Mahoney County. I went to friend of the court, earlier this spring and tried to talk to them about it, and really didn't get nowhere. She ended up yelling at me, and I ended up walking out. I showed up there with paperwork that I was in jail. So when I went to friend of the court the same day, I was also in front of Judge Brown, pled guilty to a receiving charge and accepted probation. He gave me 6 months to clear up all warrants. I went to my probation officer with that information, talked with, and he was comfortable with it too. So I didn't feel like I was out of line in any way. I'm still within the 6 months. I'm working on it. I have cash money I can pay Miss Carlson. I can't pay it from in here, and it's not on a credit card or debit card or anything. It's cash. And my PO, Mr. Sharp, is well aware of what I'm doing. He stays very aware of everything that I'm doing. But again, I didn't skip out on that court date. I was in jail in Mahoning County. I actually showed up at your office when I was put on probation, and I talked to your secretary. I had the paperwork, and she said to take that to friend of the court for them to deal with it. The lady, I forget her name, said she could care less where I was at. She wasn't dropping the warrant. That was her exact words. And and after being talked to that way, I just decided to live. I talked to Mr. Sharp about it, and he said, well, you have 6 months to work on it. So
Okay,
I'm within
that was
the-
Judge
I'm
Brown's
with-
schedule. This court's not going to ignore an outstanding bench warrant, Mr. Carlson, but the big question is, you indicate you have the ability to pay something toward this?
I have cash outside of here, yes.
Okay. When do you schedule to go back to work?
I was scheduled to go back in the middle of May.
Okay, we want you to go back to work. And yesterday you indicated you had no mailing address. You simply gave a court a email address, so that's the only way to communicate with you. Is that correct?
Well, for another week or two, yes, Your Honor. Any legal stuff I had getting mailed to Mr. Sharp's office.
Okay, well, unfortunately, that's not valid service to mail things, notices to your probation officer. So, Mr. Carlson, obviously, when you have a mailing address, you need to inform the front of the court in writing.
Yes, Your Honor, absolutely.
You're pipe fitter, is that correct?
Pipe welder, Your Honor.
Pipe welder. So when there's work, you make good money, but you move around from job to job, state to state. Is that correct? First appeared yesterday and was ordered to appear personally today, May 8th, and to pay $1,000. And Mr. Pierce has failed to appear or contact the court. He's failed to make the payment as directed by this court or suggested by this court. Currently, bench warrant shall issue. You satisfied with the $1,000 cash bond?
Yes, Your Honor.
Like bond should be in the amount of $1,000 cash only.
I will prepare that and upload that to your queue as well.
It'd be nice to have a designated law enforcement officer that could assist the court with some of these isolated pickups to make our point.
Yes, that would be.
I know Ms. LaPrade has advocated for that, correct, Ms. LaPrade? Maybe she's not listening.
Yes, sir. That was my thesis for my master's.
Yes.
That's correct.
There's a lot of merit in that, and it can be a couple of these two where, earlier this week is Tuminello. He begged the court. He was in jail. I promise I'll be back. And I'm just so frustrated that he totally blew off the court. And we know he's working at Meyer Warehouse and Applebee's. And I wish we could have a deputy go out and visit those two locations and pick him up just to make the point that he, especially just to, I'm going to keep a note up here on the bench. Ms. Hicks, if he's picked up in the absence, do not allow another judge to modify that bond.
I will not, Your Honor.
I know the judge is very adamant. We can take him on the 17th of May, if need be. I just don't want someone else to release him on a PR bond or something. But I don't know if you read Ms. LaPrade's for master's thesis. She sort of advocated to have a law enforcement assistance with the front of the court enforcement of orders.
We discussed it when she was working on it.
You've read it, haven't you?
Not the entire thing, but yes, part of it.
But yeah, there's some merit to that, but unfortunately, we just don't have the resources. But it'd be nice on some of these isolated cases to do that. Yeah, and of course, I can't ignore it. When I was informed that there's bench warrant out for Carlson, I'm not going to let someone leave this courtroom. I never did a district court when somebody's out saying bench warrants in this county. No reason. 6 months. I can see if they're out of state, but boy, I'm surprised that Judge Nichols would give him 6 months. Certainly, you can't use that if you stop for a traffic violation. The officer's not going to say, "Oh yeah, I don't have to arrest you on this because Judge Nichols gave you 6 months." No way. So, hey, but There's a couple of cleanups in the arraignment queue.
Yes.
Okay.
Let me
For
pull
the
that
record,
up.
this matter is before the court on the defendant's motion to modify custody and defendant's objection to an ex parte order. This hearing is being conducted via Zoom. Present is Attorney Ron Bruce, representing the plaintiff father, Stephen Johnson Jr. Is Mr. Johnson Jr. present with you, Mr. Bruce? There he is. Mr. Johnson is present. In addition, Attorney Sajid Khan is present, representing the defendant mother, Haley Freeman. Ms. Freeman is present. For the record, an ex parte order was entered on March 21st, 2024 by Judge Lohmeyer in this court's absence, granting possession of the minor child, Ariella, to the plaintiff father. That order should have had a hearing, a review date. This court never enters ex parte order suspending parenting time without a review date, but Mr. Bruce submitted that to Judge Lohmeyer in this court's absence, and that's what Judge Lohmeyer signs, I guess, what's ever given to her. In any event, the parties have conferred with Ms. Brower for the front of the court this afternoon. Ms. Brower has recommended that the prior parenting time, that the ex parte be set aside, that the prior parenting time, week on, week off, be reinstated with exchange at 6 p.m. on Fridays at the Kroger store in Dundee, Michigan. The parties shall meet at 5 o'clock today at the Kroger store in Dundee. Mother shall have parenting time until Friday, May 10th, when Father's Week begins. Further, again, that the ex parte order of March 21st be rescinded. Parties, all future communication shall be via app close. All appointments for the minor child shall be added to the app close calendar at the time the appointment is scheduled. That is the recommendation. Mr. Khan, is this recommendation agreeable with your client?
It is, Judge. Thank you.
I'm sorry?
It is, Judge. Thank you.
Thank you. Mr. Bruce, is this recommendation agreeable with your client?
Yes, Judge.
Okay, the last order of this court of July 2023 was week on, week off parenting time. No supervision is required. Is there still a CPS or law enforcement investigation going on, Mr. Bruce?
No, Your Honor. They were closed.
Okay. Mr. Bruce, when you submit ex parte to this court in the future, even in the court's absence, put a line in there for review date. I just don't think it's appropriate to spend parents' parenting time without getting that notice to the other party to come into court without having to hire an attorney and file a motion. So if you can do that in the future, the court would appreciate that.
Sure.
All right. Do you wish to bar your respective clients this afternoon, Mr. Khan or Mr. Bruce?
No, Judge.
No, Judge, I think we're fine.
All right. Court would like to thank Ms. Brower for assistance. Court will adopt the recommendation, and that will conclude this matter. Copies will be mailed to counsel.
Thank you, Judge. Good afternoon.
Welcome.
Okay.
See, this was a case, she said April 21st for 6 weeks. I mean, and there was no date for review date. So she's got to hire an attorney to file a motion or objection. I mean, I think when you're spending parenting time, you should always put a review date in there. You should know that. I mean, I guess maybe, I don't know. I don't like other judges handling my emotions.
Yeah.
That's just wrong. Your mom's been deprived of this child for 2 children, a 4 and 2-year-old for 6 weeks. It's wrong. I don't know what to do. What do I do? I can't prevent the attorney from going to another judge.
When they bring him in, do we look at him? Do we say there's no place for a hearing date?
Yeah, that's probably the thing to do. Yeah, we need to do a review date. The court wants to, if it's suspending parenting time, that's what this did.
Yeah.
It granted dad possession of the child to further the court. I mean, so mom had sort of forced her to go on the current attorney, as opposed to if we gave a hearing date, all she had to do was appear. It bugs me. I just say.
Yeah, maybe in the future we'll look him over and say there's no place for a review date.
You're not going to take another judge without a review date in there.
Right.
If it's suspending parenting time. You should know that. For the record, this matter is before the court on the plaintiff's motion for order to show cause. The plaintiff being Megan Ray, asking this court to order the defendant, ex-husband, to leave the marital home so as to facilitate the sale of the marital home. This hearing is being conducted via Zoom. Megan Ray is present. Is Jerry Ray present on audio?
I am.
Right, good afternoon, Mr. Ray. The two of you have met with Miss Mayville from the front of the court this afternoon. Miss Mayville has provided the court with a recommendation that the two of you agree that plaintiff shall remove personal property from the home on May 18th, which is this Saturday, 2024. Further, defendant shall provide plaintiff with information regarding the quadro, and both parties are to cooperate with the execution of the quadro. That information has to be exchanged no later than Saturday, May 18th, 2024.
Yes, Your
You both had
Honor.
attorneys. You both had attorneys during the divorce. Your divorce attorneys didn't do the quadro and finalize these loose ends.
The paperwork just needs done. It just needs filed, I guess.
Well, usually the attorneys help to those loose ends, but if you guys are do it yourself, I mean, you need to figure out how to do that.
Yeah.
So I'm not sure what information needs to be provided, but you both understand what the information needs to be provided, and you're going to exchange that on Saturday. Is that correct?
Yes.
Okay.
Yes.
And have you both agreed what personal property is going to be taken from the home?
Yes.
Yes. She's
Right. So
had
we're not
9
gonna have
months
to
and
have
she's
deputies
still.
out there.
I don't know. I just don't want no issues.
Okay, that's what I'm asking. Have you made a list? Did Ms. Ray,
Yeah.
have you informed Mr. Ray what you're going to take, and does Mr. Ray agree that you can have those items?
We did when we agreed, when we did our divorce agreement. It's just personal property, nothing of marital value. There isn't much left out there.
Ms. Ray, you complicate things by moving out of the home. It says that each shall be awarded the personal property occur in their possession. But it says you get the medium TV in your room, the furniture set, dishes, a sofa sectional, and your personal effects. That's it.
Yes.
Right.
So I took
that's all you're going to.
no.
That's all you're going to secure, right?
Yes,
Okay. Do you have a pickup truck or a trailer lined up?
I am. Yes, for Saturday the 18th. My uncle Jody is going to help me do all the moving. I had to
Okay.
flee the home a week and a half after our divorce. I
Okay,
didn't have
Mr. Ray. Mr. Ray, what time? Let's set a time the two of you going to meet. 10 o'clock?
At noon or something is fine.
Let's agree right now so that we don't have any issues or problems or confusion or misunderstandings.
That works for me.
Right.
Noon?
Yes, that's fine.
Okay. So Ms. Ray, be there at noon. Get it all done. Don't come back the next day. Get it all done.
Absolutely.
Yeah. And Judge, I would like to address this too, Judge. She's been in contempt of court since September of last
File a
year.
motion, Mr. Ray. File a motion. The only
Okay.
issue before the court today is actually about the real estate. So if she's in contempt, you file a motion. Right now, Ms.
Okay.
Ray's asking you be ordered to vacate the home because you're complicating, not cooperating with respect to the sale of the home. And Ms. Ray,
I have
first of all,
two
shame on you
offers.
for moving out of the home. Shame on you for not keeping contact with the realtor. Even though you're not in the home,
I
why
have-
shouldn't you be in contact with Mr. Welch all the time? And if he's got an offer, he should be calling you.
The
Why is
offers
it so
came in today.
complicated?
The offers just came in today.
Your Honor, I'd like to speak
Ms.
if I
Ray, here's
could.
what the court's going to suggest. Call Mr. Welch and tell him you wanted to meet him at the home at 12 noon on Saturday. Easy. You've employed him as your realtor. You two of you call him, tell him you want him there at 12 noon on Saturday to discuss these offers, what needs to be done. Listen to your realtors. You're both throwing money out the window if you don't work together to market this home properly.
Your Honor, the issue with the property is that it's depreciated as he's been living there in the last 8 months, and Corey
Okay,
has
yes. Ms. Ray, you should not have moved out. You should have made sure that the home was protected, but you've moved out. And then if you're going to move back in, the court suggesting contact Corey Welch, tell him you want to meet him at noon on Saturday while you're removing some things and discuss with him what needs to be done, whether the offer that's been presented should be accepted. If it's too low, then what needs to be done to improve that offer.
Okay,
And then
he changed the lock.
If you
I
need to
cannot even
modify or
get in
make
it.
some additions or corrections to the home, you should make those improvements.
I can't get in. He changed the locks.
Mr. Ray, you cannot change the locks. Mr. Ray, you can break the door if you want. I mean,
Okay.
it's still a marital home. Mr. Ray, if
Thank
you
you.
cannot, you have no authority, no right to change locks in that home.
Even though she
That's
moved
why
out?
That's why I haven't been able to do anything in 8 months. He changed the
Well,
locks on me. I went to go
Ms.
home.
Ray, first of all, you should have consulted your attorney before moving out. You put yourself in a bad position. So, Mr. Ray, are you going to provide Ms. Ray with a key to that house on Saturday?
She moved out though, Your Honor.
Mr. Ray.
So I gotta let her
Ordering
come
you-
freely to the house?
Mr. Ray, Ms. Madel, put in the order, the defendant, Mr. Ray is ordered to provide the key to the home to Ms. Ray on Saturday.
All right.
Mr. Ray, you have no right, no authority to change the locks in the home. It's still a marital home. Ms. Ray has a right to go in there. If you don't want her in there, then you file a motion for exclusive use of the home.
Your
You
Honor,
complicated things by moving out, Ms. Ray. So you meet with Mr.
But my
Walsh on Saturday and
attorney-
ask what needs to be done to properly market this home.
my
And-
attorney recommended I leave the home before I was physically assaulted.
Okay, well, that's up to you, Miss Ray. Mr. Walsh should have your cell phone number, so he gets an offer, he should be communicating with you just as much with Mr. Ray.
He does not. And as a matter of fact, the last conversation I had with Corey Welch, he told me he was unable to sell that house while Mr. Ray lived in it because it's a filthy disaster.
It is not. And he told me he did not have
It
that
is
conversation with her.
Right, so
I
meet
have
with
it
him
in
and get a
writing.
letter. Miss Ray, he's not here. This is hearsay. So you get a letter from Mr. Welch and present that to the court that this home, he's not willing to market this home without Mr. Ray being in possession. Then the court would consider it. You can.
I'll file a motion. I'll file a motion today.
We've already filed the
Thank you.
motion. I'm gonna put this over for a couple of weeks. I want you to contact Mr. Welch today. Tell me you want to meet him on Saturday, whether it's 12 or 1. If you want to get me or 11 o'clock, sometime before, after, or during the time that you're moving the personal property. And both of you should be there and discuss with them, how do we maximize our return of this home? You're both getting the short end of the stick. Mr. Ray, you should cooperate too. If there needs to be improvements made, make them. If you need to hire them done, then you agree those be paid out of the proceeds.
Your Honor, I have an offer. I have an offer for $215 on the house. If she wants to accept that, we'll go with that, and I'll keep the house. I'll pay her out, and we can be done with this today.
And
Won't have to
here
deal with
we
it no
go.
more.
The house was listed at 245. Corey could have sold it at 245 if I could have gotten in there to clean it up. But I can't get in there to clean it up, and it's a
Mr. Ray,
disaster.
you can clean it up on Saturday. Mr. Ray's
My God.
ordered to provide you with the key on Saturday. So meet with Mr. Welch and both you discuss with Mr. Welch what needs to be done to improve an offer. He may
And
say just
I'd like
clean
to
up.
bring
He may
this
say
up,
paint a
Your
room.
Honor. Your
So,
Honor,
Mr.
this,
Ray, you both meet on Saturday. You both call Mr. Welch and let him know you need to meet him there, whether it's 11:30 or 12 or 12:30 on this Saturday, and talk with him about what his recommendations are. And I'm gonna give you a date to come back in 2 weeks.
okay, Your Honor, I have a question
How about May
also.
23rd? How about Wednesday, May 22nd, at 1:45? Are you both available?
Yeah.
Yes.
And
I do have
Ms.
a
Ray,
question.
Have Mr. Walsh appear. Mr. Walsh can provide some testimony. Give Mr. Walsh, of course, my ID number. He can appear and he can provide the court some testimony at that time. If he thinks that Mr. Ray is being obstructionist and he is preventing the showing of this house, he's canceling appointments, the court's gonna order Mr. Ray out of the home. And you can
All
move
right.
back in, Ms. Ray, right?
Thank you. Yes, I could and get it ready for sale. The house itself appraised at 239, and it's so bad that we're getting offers of 215.
The
We
house
hadn't
appraised
got-
for 225. It's in the paperwork. It's
No.
Okay,
225.
talk with Mr. Walsh about that. We'll see you back on May 22nd, 1:45. Put that on your calendar, May 22nd, 1:45, to review the sale of the home. And have Mr. Walsh appear on that date, Ms. Ray.
Thank you, I will.
And Mr. and Ms. Ray, you need to work together on this home. Otherwise, I'm gonna appoint a receiver to sell it. And then the receiver's gonna get, that attorney's gonna be paid off the top of the proceeds. You're gonna lose another $5,000. Because if you can't work together on this, the court's gonna appoint a receiver. The receiver will be paid out of the top of the proceeds. You're both gonna be on the short end of stick, so it's contrary to your best interest to not work together.
Okay, can I ask a
So
question? Your
provide
Honor?
Miss Ray with a key. Once again, Mr. Ray, you cannot lock her out of the home. Provide her with the key on Saturday, and meet with Mr. Walsh on Saturday and get the personal property out of there. So at least that issue is done. We'll see you back on May 22nd. It's Wednesday at 1:45 p.m.
Your Honor, can I say something?
Go ahead, Mr. Ray.
Oh, okay, so if she comes in the house when I'm not here, what happens when my stuff disappears though?
We'll take a picture. If it's missing, then video everything in there. If it's really valuable, You got gold bars sitting around, put them in a safety
Right.
deposit box.
I can't.
Yeah.
Okay.
All right. Will I get paperwork in the mail on this?
Yes, we're gonna again, you're not gonna offer to get it before Saturday, but she's gonna be there around noon on Saturday. You're both gonna call Corey Welch and get him out there so you can talk to him together to see what his recommendations are. He may recommend to accept that offer, Miss Ray. But the two of you should talk to him at that time, Mr. Ray, provide a key to Miss Ray. And Miss Ray has the right to, if she wants to move back in the home, she can do that.
Well, actually, we were trying to reconcile, but you know, she's spent the night many a times here.
Okay,
You
we'll see on May
cannot
22nd then. This is
stop
it's 2 weeks away. All right, you can both zoom out and you'll both get a copy of this order. If you want a copy today, you come down to the front of the court and get it. Otherwise, it's going to be put in the mail and tomorrow. Hopefully you'll get it on Saturday, but maybe not. There's no guarantee. But you certainly get it before the review date of May 22nd.
We've got it scheduled for the 18th for her to come pick her stuff up, is when it's the 18th.
Yeah, you're going to meet at the house this Saturday. Miss Ray's going to remove personal property. Let's at least get that separated, get that issue done with. Miss Ray, don't take anything else that you're not specifically awarded. Don't take anything else not specifically awarded to you.
No, sir, I wouldn't. And there's not much there anyway, except for my thing.
Okay. And call Mr. Welch when you get off the phone here and tell him you need to meet with him on Saturday at noon.
Okay, thank you.
Well, and the last ROA says that if presently pregnant. That was March 13th, which is, yeah, child's
Maybe
reborn.
you need to try the breakout room.
Doesn't matter.
Megan?
3 months, yeah.
Yes.
In the breakout room.
Probably their alleged biodata.
Excuse me.
Supposed to be in the breakout room.
I keep getting kicked out of the breakout room. I'm very sorry, and I have no audio. I can't hear anything that's going on.
You can't hear the court?
When I was put into the break room, I could see Mr. Ray and his attorney, but I couldn't hear anything. And I also saw the mediator, and then I was immediately kicked out. I don't know what's happening here.
Okay, we'll put you back in there to the sale of the former marital home, as well as disposition and collection of personal property. Post judgment, this hearing is being conducted via Zoom. Present is the plaintiff, Megan Ray. In addition, the defendant, Jerry Ray, is present, who was retained Attorney William Godfrey. This hearing again is being conducted via Zoom. Good afternoon, everyone.
Good afternoon, Judge.
The parties have conferred with Mr. Pratt. Mr. Pratt has recommended this matter be adjourned to June 26 at 1:45 in order for the plaintiff, Megan Ray, to retain an attorney. Is that
Yes,
your
please.
request, Ms. Ray?
Yes,
Okay.
please.
Mr. Godfrey, any objection?
No objection, Judge. Thank you.
All right. The parties were before the court on May 8th. Mr. Godfrey was not present. The court ordered that the plaintiff remove her personal property from the home on May 18th. And Mr. Ray would provide plaintiff with information regarding the quadro. And that be exchanged on May 18th and filed the meeting at noon on that date. And also meet with the realtor, Corey Welch. Has that occurred?
No.
Ms. Ray did not appear. Ms. Ray did not appear on May 18th at noon, Judge. It was
Ms.
well
Ray,
after.
that was ordered by this court, Ms. Ray. Why didn't you do that?
I ended up having to work until noon, and I called.
Miss Ray, it's not an excuse.
Well, I spoke with Mr. Ray several times about it, and he said it was fine. I
Okay,
do have
so
those in text message.
Has a home been listed with Mr. Welch?
It has.
Okay. Is that correct, Mr. Godfrey? Both parties signed a listing agreement with Mr. Welch?
Yes, Judge.
Okay. Because if not, the court was going to appoint a receiver. I'm tired of these parties coming back every week. So have you agreed upon a new date, Ms. Ray? You get your property? Let's be done with this. I can't hold your hand throughout these proceedings.
Yes, Your Honor. So what would be a good date? And there is a personal protection.
You gave a date. You didn't tell me when we're on May 8th, that 10 days later that you couldn't do it. You agreed with it. Both agreed with that date and that time.
I did start a new job. I'm sorry, Your Honor. I got lowered my hours at work, so I did find a new job. So I ended up having to work that Saturday until noon. can get my things anytime, but also I would like to know, there's a personal protection order in effect, so.
Miss
Judge,
Ray,
I can
you can
try to
spend
work a
money, you can
date.
hire an attorney, Miss Ray, and have that attorney, you can hire a private security guard, you figure it out. The court tried to help you in this regard, but you've ignored this court's order. You could have gone, if you got a noon, work at noon, couldn't you have gone home then at 12:15?
Well, we talked over the phone and we had a long conversation. Actually, he agreed to have me get everything out at the time of sale. We had a really jovial conversation. So I understand the frustration of the court because I've been living with this for 8 months. And so you'll see a lot of that via my attorney, the back and forth, the text
Miss
message.
Ray, you're pushing the
all of
patience
that.
of this court. You're pushing the patience of this court enter orders and you ignore them.
I don't ignore, Your Honor, and I have evidence.
Why, hold on. I still haven't gotten a legitimate answer. Why didn't you appear at noon or 12:15 if you got to work at noon?
I had to work because I work in
Said you got
Riverview.
to off work at noon, Miss Ray.
Right. And I talked to Mr. Ray and we had made an agreement that I would be able.
Not gonna buy it. You don't need the court's involvement then. If you're gonna reach your own agreement, you handle it. Why should you have the court have you back here in a month to take up more time in this court, Miss Ray, when you ignore court orders?
I wasn't trying to ignore.
Contempt of court for violating this court's order. Miss Ray, of course not, please. You have no credibility with this court. Mr. Godfrey, do we need a review?
Judge, I mean, I'm willing to work or try to work with Mr. Petrangelo. That's who Ms. Ray has indicated she intends to hire or retain.
Yes.
All right, then if necessary, the court will award attorney fees, Mr. Godfrey. If Ms. Ray is taking things on her own hands and reaching her own agreements, now saying this court's order, the court will reluctantly adopt the recommendation. We'll put this on the court's dock for last time, June 26th at 1:45 p.m. The court would suggest, Ms. Ray, schedule it through your new attorney another time to get your personal property. Let's get this done.
Yes.
Anything further, Mr. Godfrey?
No, Judge, thank you.
I'm sorry, I'm just frustrated. So we'll see everyone then on a date in July.
Judge, on that date in June, I will try to work with Mr. Petrangelo, but the judgment of divorce on the Quadro, Ms. Pastrana indicated that there is not enough language in the judgment for her to figure out what to do on it. It doesn't say if it includes premarital, because there was some of the 401k was premarital. It doesn't have the division date in there. Normally I would say it's the marital portion and the division date being the evaluation date being the date of the judgment of divorce, but the judgment does not say that. So if I can't work something out with Mr. Petrangelo, I'll file a motion and put it on for the same time.
And the court would concur with your line of thought, Mr. Godfrey, for whatever it's worth. In any event, we'll see everyone back on June 26th at 1:45.
Thank you, Judge.
You're welcome. Sorry.
Your Honor,
We're done. We're done, Ms. Ray. We're done. I'll talk to your attorney. You can zoom out. For the record, the DO is a post-judgment case regarding sale of the marital home, enforcement of the terms of the judgment of divorce. The other matter is the personal protection order that is respondent Megan Ray's motion to terminate the PPO entered in favor of Jerry Ray Jr. on May 20, 2024. Present is Attorney William Godfrey representing Jerry Ray Jr. Mr. Ray appears to be present with Mr. Godfrey. Attorney Petrangelo withdrew representation of Megan Ray in both cases. But John Danielski, Attorney John Danielski, has appeared this afternoon. Mr. Danielski, will be fine appearance in both matters?
Yes, I was just retained Monday night, Your Honor. I sent my runner. I didn't, but yes, the answer is yes.
Okay. The court's frustrated with this case coming back. The parties have not complied with orders of this court. So they should resolve the mess that they've created. The court has very little patience with both parties. So what, you're asking to adjourn this matter? I've reviewed it, I prepared for it, I've spent unnecessary time trying to, and I suggest the parties, if they can't resolve it, I'm gonna appoint a receiver to handle the sale of the real estate, and they can pay for that receiver.
Well, Your Honor, Mr. Godfrey and I have worked together for a long time. We did have a conversation yesterday. I apologize that, for not contacting the court right away regarding the adjournment. I just got involved, and as Mr. Godfrey knows, and I think Your Honor knows, Ken is leaving
That was
me.
Monday night. Today's Wednesday, Mr. Danielski. A little heads up would have been nice.
Yes, I apologize, Your Honor. I wasn't sure what was.
Are we moving toward a resolution, Mr. Godfrey?
Yes, I spoke to Mr. Godfrey, and I plan on, I haven't reviewed the whole file. I will have it reviewed by Sunday, Your Honor.
Two simple issues, Mr. Danielski. Two simple issues. Sell the home and entry of a quadro.
Well, a receiver may be the right way to go, but I'd like to talk to Mr. Godfrey first to see if we can resolve it. Obviously, I agree, Your Honor. These are simple issues. When I was contacted by Miss Ray, I said, well, this should be simple, should be easy. So I have to look at the file and find out what the heck's going on. Why isn't it easy? So, or why hasn't it been easy? But I'm hopeful to get it resolved. Hopefully we can get it done here.
Have you reviewed Mr. Petrangelo's memorandum that he filed with this case on behalf of Miss Ray?
I have it in the file, Your Honor, but once again, I was retained. I was in trial all day Monday, and I was in a mediation almost the whole day yesterday, and I haven't had a chance to review everything. So I'm going to be here all weekend, and I'm going to read
Just
everything.
want to make sure you had it, because Mr. Petrangelo lays everything out. And of course, the court, as previously ordered, Mr. Ray was to, of course, Ms. Ray was to remove personal property from the home on May 18th. She didn't do that. Mr. Ray was to provide information regarding the quadro and cooperate. He apparently has not done that. So neither party has done anything cooperating with this court. So if there's not a resolution, the next week, court's can order a plain receiver.
Seems like a simple case to me, Your Honor. I just have to read everything to find out why hasn't this been done.
Mr. Godfrey, your thoughts?
Judge, the problem that I had once I got involved in the case is as to the judgment of the divorce, as to the quadro on top of page 5 of the judgment, it merely says to the value of the retirement account shall be equalized. My client was of the belief it's the marital portion. I don't have a transcript, or I was hoping to work out with Mr. Petrangelo that it would be the marital portion of the retirements that would be divided. Mr. Ray does have some premarital portion. Mr. Petrangelo and I had talked about that at length, but he no longer is in the case. I've talked to Mr. Danielski about it, and we're going to talk about that and see if we can get the global settlement. The second issue that is complicating it, not so simple, is on page 2 of the judgment. It refers that plaintiff, that's the wife, will start contributing to the mortgage payments, which she hasn't done, but then which I can calculate pretty easy. That's $500 per month. There's 10 months, it's $5,000. Not difficult. But the next sentence reads, and I didn't draft this judgment, nor did John, all other household bills will be paid by the party that has previously paid them until the house is sold. My client is of the belief that his ex should have been paying 3 bills. Mr. Petrangelo and I discussed that. There was some disagreement, and I'm not sure where that ended because Mr. Petrangelo isn't part of that anymore. So those, while they're not terribly complicated and they're not terribly huge in monetary amount, I think with a new attorney, and John and I can sit down and he's going to work on Sunday, and he said he would have an email to me Sunday night, first thing Monday morning, and that's why we're asking the court to entertain us next Wednesday.
Are you available at 3 o'clock?
Judge, we were looking at hopefully the first thing in the morning, only because I've got a mediation scheduled in the afternoon of that date.
Got some every 30 minutes, Mr. Godfrey.
8:30, Judge, 8:30 or 9 in the morning.
Got some at 8:30. I've got something every 30 minutes on July 3rd. Okay. The only time I have available is 3 o'clock.
I will make it work, Judge.
I'll make it work, Your Honor.
Right. How many how many years does Mr. Ray, for the court's information, claim his pension was premarital?
Judge, I've got the dollar amount exactly as 4,936.05, and that's as of the month of marriage. And then the month before he got, or they got divorced, it was 35,160.34. So it's just whether or not we subtract 4,936.05 or not. That's the question.
Right, and Miss Ray had a very small, nominal, I think, what, $14, $15 premarital on her.
And I've got that paperwork. It's $15, Judge, and I'm not going to spend time subtracting $15 out of this equation.
Right, and with respect to the $500 payments, obviously, Miss Reagan or Miss Ray Compke, I think she vacated the home, and I think the intent of the parties was that the status quo. So whoever paid those miscellaneous household bills prior to entry the judgment would continue paying those until the home was sold.
And that was our belief, Judge.
Judgment.
Right, that was our belief, but there was balking about paying for it. My understanding was she was responsible for the electric, water, and garbage, and she did not pay those.
Okay, if that was the status quo, if she was paying those prior to the judgment, then she should continue paying those. The judgment does have the language status quo in parentheses.
It just didn't. It didn't describe what that status quo was. That's so.
I think the court would probably take testimony in terms of the prior history, who had been paying them during the pendency of the divorce action.
And that's what I assumed the court would do, and that's what I had indicated to Mr. Petrangelo.
Right. Likewise, with respect to the retirement, I'll let the parties work through that. But if in fact there's common interpretation would be that they would divide the marital portion of the retirement of the pensions. But I'll leave that to counsel if they want to argue that. We're talking a pretty short-term marriage of 3 years. So the basic people should be back in the position they were. So if in fact there's disputes about the retirement, that would be the court's inclination is to certainly hold off making a decision until you hear testimony for the argument. But it seems like the marital portion of the retirement should be the ones that are divided. But in any event, court will adjourn this matter to July 3rd at 3 p.m. And we'll also adjourn the PPO, the motion to make the PPO on the same day and time.
Thank you, Judge. If we have an agreement, would the court entertain us earlier?
Absolutely. You call and we'll squeeze it in. If we don't
All
need to, if there's no further argument or testimony to be taken, just call me and we will squeeze it in. Even earlier that July 3rd, if we have some resolution that morning, we can do it like at maybe 8:45, 9:15, something like that.
I always appreciate the court taking agreements, Judge. Thank you.
Okay. All right, Ms. Brough, if you wouldn't mind to indicate for an order that both these matters are over by agreement to July 3rd, 2024, 3 p.m.
Your Honor.
And I would hope that Ms. Ray will get their personal property out of the house in the meantime. You get some of these little things. Let's get these things done. She was previously ordered to do it on a certain date. She didn't do that.
Your Honor, if I didn't want to take time on the record, if Mr. Godfrey could be available for a phone call right after the hearing, I want to set up a time for him and I to talk on Monday that works for both of us, and we can talk about this, what Your Honor just mentioned, this personal property.
That'll be fine, Judge.
Okay.
We've already spoken today a couple of times, Judge, so hopefully I'll call John and we'll do it right now.
Well, you have the parties present. Right, thank you. All right, this matter is adjourned. See you next week.
Judge.
Thank you.